End users of interpersonal communication services have the right not to receive unwanted commercial calls, except if there is prior consent from the user to receive them, or unless the communication can be covered by the exceptions provided for, in Article 6.1 of the GDPR, which are the fulfillment of a mission carried out in the public interest and legitimate interest. Therefore, if the user does not give prior consent, companies are not allowed to call the user by telephone for commercial purposes, unless such communication is covered by the exceptions mentioned. In order to prevent companies from covering all their spam calls with legitimate interest, the Spanish Data Protection Agency has established limits to this legitimate interest. In the event that there is a prior contractual relationship between the user and the company, legitimate interest may be alleged. Is not entirely effective. Many companies do not cross-check their data with the Robinson list, and despite this make unwanted commercial calls to users registered on the list. The modification of the General Telecommunications Law adds that companies will not be able to call the user directly if there is no legitimate interest or public interest. Therefore, special attention should be paid when accepting the terms and conditions, as these often contain clauses on consent to receive commercial calls. From Auratech, we are at your disposal.